I'm Matt Kishard, and this is No Holds Barred. In this episode of No Holds Barred, I want to talk about bail and many of the misconceptions about bail. So bail, we often hear about bail. I was on a flight recently and talking with a New York City police detective who was very upset about no bail program in New York City. Advised me that she believed that's why crime was out of control. And we had a nice little chat about it. I went home and took a look at our own bail statute here in the state of California and thought about bail. I think it's kind of important that people, what is bail and how does it work? Well, let's take up Penal Code Section 825. A defendant shall in all cases be taken before a magistrate without unnecessary delay and in any event within 48 hours after his or her arrest, excluding Sundays and holidays. So that's Penal Code Section 825. Well, what does that mean? That means if somebody is arrested within 48 hours of that arrest, that assumes they are in custody. And when they are in custody, within 48 hours, they need to be taken before a judge. And in that case, bail is often set. The 48 hours, however, can be extended to 72 hours. And how does that? Well, it has to be when a magistrate is available, when court is in session. So that person that gets arrested on Friday morning may not appear before a judge until, say, Monday or Tuesday morning, can extend out to 72 hours. So how does bail come in? Well, interestingly enough, we have 58 counties in the state of California, and each superior court sets its own bail schedule, believe it or not. So there isn't a bail schedule that fits across the board. So all the superior court judges, by a majority vote each year, release a bail study. And I did a little research and pulled out the Contra Costa County felony bail schedule, January 1st, 2023, for the year. And it's pursuant to the Penal Code Section 1269B. The Superior Court judges in each county shall prepare and adopt. And that's, in fact, what happens. Well, let's take a look at some of these bail amounts. So when somebody is arrested and they are in custody, before that 48-hour period, they can post bail. So if they get right in, they can post bail. And then that 48-hour that we talked about, or up to 72, doesn't really apply, because if they post bail, then there is a date set at which they come in for their arraignment. But when you look at some of these, I think it's kind of interesting. What are some of the ones we've talked about? Well, what is bail for resisting arrest or threatening an officer? In Contra Costa County, it's $20,000. How about threats to the life of a judge or an official? That's $250,000. So at one point we talked about criminal threats, and a criminal threat, if it's made to a judge or an official, it can be $250,000 bail. Possessing false citizenship documents, $50,000. Threats to witnesses, $75,000. Murder with special circumstances, no bail. Other murder, $1 million. And I could go on and on and on, but just giving you some understanding of how bail is actually set, and it's set by the Superior Court in each county, and then some of what those bails are. Now, we all know, we've heard about that, posting bail as you get a bail bondsman, and it can be up to 10%. So that person that threatened that judge and has $250,000 bond, theoretically could post bail of $25,000 or spend $25,000, and the bail bond will post the balance of it. And let me tell you, you don't get that back. So if you use a bail bond, now I will say many bail bonds will give a reduced amount. Sometimes you hear, well, they want 5% or 6%, something like that. But if they post that bond, that is gone forever. So the person who gets accused bails out at $250,000 bond. Now, if they pay it themselves, straight up $250,000, and at the end, and they appear for arraignment, they do whatever, even if they go off to jail, they get their $250,000 back. In some cases, however, that some of that money that's been deposited with the court can go to fines and penalty assessments. But that's kind of not the point of what I want to talk about. I want to talk about bail. Many people think that it's the rich get out and the poor stay in. And the fact is, our California Supreme Court says, and there's a rule, that a person has a right to be released prior to trial under conditions to adequately protect the safety of the public and the victim. And so that's our Constitution. The California Supreme Court, in a ruling within the last couple of years, said no person who does not pose a threat to harm or to flee should be denied release simply because they cannot afford bail. So that's kind of the misconception. People think, well, we're just letting everybody out. Well, actually, no, there is a bail schedule. And in fact, if the law says a person can't afford it, but they do not pose any harm and they don't pose a threat to flee, they should be allowed to be released. Who makes that decision? A judge makes that decision. So that's kind of where people have to understand is it's just not automatic that everyone who's arrested, I can't afford it, so I automatically get out. No, you have to go before a justice. The justice then makes a decision. And many times we have what we call bail studies. It goes to the probation department. They do a bail study. They look at the background. They look at the offense. They look at the ability, any priors. They look at a number of things. Is the person a foreign citizen? Will they flee? And they come back with this bail study. And the court then makes a determination as to whether or not a person should be allowed to be released on their own recognizance, or in many cases, the amount of the bail is reduced significantly, but that's kind of all on the judge. Now, you understand that that's how our system works. We look at the fellow who, FTX, very famous case, he had a bond in the millions, but posted the family sufficient property and security so that he got out. And recall, guess what? He made statements that the court believed to be threatening statements and in violation of the terms of his bond. And guess what? In spite of the fact of posting that incredible amount of money, he's back in custody, and he has remained in custody for some period of time. So, likewise, I want to say if somebody doesn't pose a threat or they're not liable to flee, likewise, no one who does pose such a threat should be able to buy their unconditional release. So that means that just because somebody is wealthy, but if they pose a threat, the court can impose additional restrictions, additional bail, more than some of these numbers that I have just indicated to you. Keep in mind, we've heard about bail bonds. So what is that? That is a company that secures a bond and, in fact, guarantees. They guarantee that, so that $250,000 bail that we talked about for threatening an individual, the bail bond people, for a fee, will enter into an agreement that they will be responsible for that. They don't actually put up the entire amount, but they will be responsible for it. And then what happens if the person doesn't show up? Well, we see all the movies about bail bonds people chasing them down because they need to get that person and bring that person back to court so that the bond gets exonerated, so they're not responsible for it. Because if the person were to flee, the bail bond company has pledged that $250,000. They only got, let's say, $25,000 for that, and they're now out $225,000. They need to find that person and get him to return to court, so that in cases like that, oftentimes the bond goes way up or the person is put into custody with no bond. Now, when we go back to that 48 hours, that's kind of interesting because in many times we'll see that somebody has been, I had a case in which I was a prosecutor, and a person was arrested for murder, and they were taken into custody, and by the next, by 48-hour period of time, and there are no holidays or weekends in between, the police investigation had not proceeded to the point where the district attorney wanted to file the case. So the person was released with no charge. They were released. We call that an 849B of the Penal Code, released. Now, that doesn't mean that the case is over. That simply means that there wasn't sufficient time or evidence to actually file that case. So the case was not filed. 2 weeks later, it was filed. The person was rearrested. It was a murder case with very, very high bail. That's how those things kind of can work. Now, something I do want to say, and it kind of goes back to a case that I was involved with at one time. At one point, a person was charged with murder, arrested and charged with murder, and then dismissed because there weren't the witnesses upon which the case had been originally based, fled, couldn't be found, so the case was dismissed. The government has 2 bites at that apple. And in that case, we found those people. I was involved with that case. We refiled it. We put on a preliminary hearing. The person was held to answer. But in that case, there is no chance that if the case had been dismissed for any technical reason, we had our 2 bites at the apple, and that was going to be the end of it. So we had to be very careful about that. So that's kind of how cases work with things being dismissed. But it doesn't just mean that a case after 48 hours is going to go away. It may come back up. There may be evidence, and that's how that works. But very important to understand, if you're arrested, we've got 48 hours within which to charge you or bail. And now people ask me, well, wait a minute, what about night court? We see it on television all the time. Well, there's some communities that have a night court and that maintain that, and weekend courts, that 48 hours is absolutely firm. And within 48 hours, whether it's a night or a weekend or whatever, they have a magistrate available to determine whether or not that person, to arraign that person and see whether or not bail is going to remain the same, going to be increased, or in some fashion, person charged. So at any rate, I do think it's very interesting to look at these various bail schedules and see, I know a recent case that I'm familiar with is where there was a $3 million bond was requested, and it was actually a sex case. Now, in reading the statutes, they're not supposed to stack. In other words, say, well, you've got these multiple cases, but in some cases they can be stacked. You can look at each individual offense, and let's say each one is a $200,000 bond, multiple offenses over time, stack it up, and that's where you get to these $2, $3, $4, $5 million bonds that we hear about oftentimes. So a couple more kind of interesting ones you might find. A sexual battery is a $50,000 bond. That would be a felony. A corporal injury to a spouse. We've often talked about domestic violence cases on no holds barred. So what would bail be? Corporal injury on a spouse, a cohabitant or parent, or his or her child with a prior. So that's $100,000. Elder abuse. We've talked about elder abuse. So let's see. What's What's the basic bail for an elder abuse case? $100,000. Those are very high bails. Stalking, interestingly enough, we had a session just recently on stalking. Stalking is a $150,000 bond. Carrying a loaded firearm. So I tell people, unless you have a permit, you are not entitled to carry a loaded firearm either in your vehicle or on your person. And that's a felony. It can be a felony. If it's a felony, it is $50,000 bond. We see evading. So what does that mean? Oftentimes now on television, and that seems to be a big thing. People evade the police oftentimes. We've talked about that on No Holds Barred, where many agencies have no pursuit policies. So many people think, I can evade the police. Well, you're unlucky if you try to evade an agency that has a policy that says they can be pursued, or you have a helicopter overhead. What is the bail for that? It is $50,000. Driving under the influence with bodily injury, $50,000, and for each misdemeanor prior, an additional $20,000. So it could be $70,000. So kind of on and on and on. There's so many. So I would invite any of you who have prior offenses or anything, or just for interest's sake, just go online and look at the Contra Costa County bail schedule for felonies or misdemeanors. Very interesting. And I think it's important that we all understand bail isn't something where just the rich get to pay and the poor don't have to pay. There are many ways in which courts look at the individual offense, look at the individual, and make a determination as to whether or not the person is a danger to society or is likely to flee. We often hear many times about taking somebody's passport. That's a condition of bail in many cases, or release. The court says, okay, you are to give your passport so that you don't have it, and so you don't have the opportunity to flee. And that's critically important. I haven't gone and done any research on that New York statute. So that New York police detective seemed to be saying that everyone was free on bond. I seriously doubt that. I seriously believe that probably the same as here in California, that there is a magistrate who's going to look at the circumstances and in many cases release somebody on their own recognizance. So that is something that happens. Somebody appears in front of a judge, and their lawyer asks them if the court will release them on their own recognizance, say, look, this person is a member of the community, lives and owns a home, this is the first offense, there are a number of reasons why, and the court then would release them on their own recognizance. And of course, we do hear about those cases in which somebody is out on bond or released on their own recognizance, and what do? They reoffend. And if they reoffend, there are heightened bond requirements and heightened charges. So people, if they're out on bond and they commit another offense, that is an offense in itself, or certainly an enhancement, and can increase the penalty for that. So we have a system that seems to be working, and nothing unfair about it. And that's why we have judges who, the neutral parties, can make determinations as to whether or not somebody should get off. I want to go back and mention that one issue that I said under the law, and it states no one who does pose a threat should be able to buy their unconditional release. And that's an important term, unconditional release. Now, they may be able to buy their release, but there are conditions that are put on many such releases where somebody pays a high bond and their releases. You can't leave the country. You must give your passport to us. You can't contact any of the witnesses. In many cases, you can't leave your residence. And I know our FTX fellow, that was one of the original, couldn't leave his residence except for certain purposes, couldn't contact witnesses, couldn't engage in any of the conduct that he engaged in. And in fact, I believe he made a bunch of statements that the court believed was a violation of the conditions of his bond. So even that rich person, guess what? Back in custody. If you have any questions or comments about this, please enter them. Happy to read them. Hit the like button, hit the subscribe button, and we'll see you at the next episode of No Holds Barred.